Hi, my name is Eric Willison. I'm an attorney in Ohio, and I've been practicing since 1996. I'm going to talk to you today in this video about the mechanics of filing something with the court. Go with an analogy here. If the law was about making and drinking wine, what I'm going to tell you here is about how to make the glass bottle and what the cups should look like. This is not about what should go into the cups and what should go into the bottle and how you ferment the grapes and you do this thing, you use these grapes from France. No. We're just going to talk about the receptacle, the piece of paper that you're going to put your arguments on and then go file them with the courts. Now, as we're getting more and more modern here, there are still courts that use paper. They're becoming a little bit fewer in number, and more courts are turning to electronic filing. But even if you've got a court that uses electronic filing, like the federal courts, it's 99% no paper anymore. There might be a few things where you have to have some paper, but mostly it's all PDF. But even if you're in an electronic filing court, it's still paper, because when you look at it on the screen, it looks like a piece of paper. That's our visual reference point. So we're going to talk about basically paper. All right. Now, the first thing when you're talking about filing something, there's pleadings that you file. The first part of the lawsuit, the initiating document that you file in a civil case, is going to be the complaint, and then there's going to be an answer, and then there's also what are called motions. As you're going through, you're moving that maybe this bit of evidence be excluded, or maybe this person should be dismissed from the case, or maybe a motion to compel discovery because, Your Honor, the other side won't turn this stuff over. We're entitled to it. We've tried to work it out amongst ourselves. They're being bullheaded. Your Honor, I got no choice. I need you to come in there and tell them, turn that stuff over. That's my motion. The other side file a memo contra, okay? But what you're going to have on any piece of paper that you're going to file electronically or physically, the first thing that you're going to have across the top, centered across the top, is the name of the court. It may say, in the municipal court of Franklin County, Ohio, and then sometimes under that you'll get a little bit more detailed and you'll put civil division if it's a civil case, or criminal division if it's a drunk driving case or whatever. If it's a divorce court case, then it might say, in the Franklin County Court of Common Pleas, Division of Domestic Relations, or something like that. And then that's going to tell us from the pleading what court it's in. It might say, United States District Court for the Southern District of Ohio, Eastern Division. That's what it will look like for federal court. So that's going to be centered. It's going to be in the middle, at the very, very, very top. Now, right under that, we're going to have to know on the left-hand side, we're going to see who are the parties. There's going to be the plaintiff and the defendant. Now, in the complaint, it's going to be necessary to list the plaintiff, and all the plaintiffs, in fact, and it's going to be necessary to list their addresses, or the addresses that they're going to be using for the purposes of filing stuff in this case. So if there's three plaintiffs, it's going to be Mary Smith, Joe Jones, and Frank Adams, and it's going to give each one of their addresses below. And then it's under that, it's going to say versus, and then under that it's going to be the defendants. And it may only be one defendant, but it'll give that defendant and the address, okay? That's going to be on the left-hand side as you're looking at the paper. Then there's going to be a bunch of dividing lines going down the middle, and maybe there are going to be colons or brackets or whatever, just sort of a visual barrier there. And then just to the right, on the right-hand side of the paper, now we're going to have it just under where it says where the case, what court it is. We're going to have case number, and it's going to be case number 2020 CVG 0019143. Okay, and that'll be the case number, and the clerk is going to assign what the case number is. It's usually done as just sequentially as people file them. Now, when there's these little initials in it, firstly, you're going to see, 2020. That means it was filed in 2020, or it might just say 20, and you just have to guess that it's not 1920, that it's actually 2020. Okay, and then these little three letters, or sometimes two letters, if it says CV, that's usually going to mean it's civil. If it says CR, that's usually going to mean it's criminal. But from there on, it's kind of tricky to understand. You kind of have to go to the local rules. Like, it doesn't say, in Franklin County, it's going to say an eviction is CVG. G stands for eviction. I don't know why, but G stands for eviction, okay? If it's CVF, then that means it's going to be a contracts case, like some credit card companies suing you for something. Over in Court of Common Pleas, Franklin County, CVH, that's going to be a consumer case. H for consumer. Again, each of these little letters is going to mean something. And then finally, you're going to get this sequence of numbers. The very first one that gets filed that year is going to be 0000001. And then as we get into December, it's going to be 0765431. So that's going to be the case number for it, and that's going to be how it's going to be referred to from then. Under the case number, you're going to have who the judge is. Judges are typically done through random assignment if there's more than one judge in your county that's in that division of the court. And then sometimes judges will have a magistrate who works under them and will handle minor matters that come up for a dispute. So you might have Judge King and Magistrate Prince. We'll be hearing some of the minor things under that. And then right under where it says the magistrate's name, if there is a magistrate, it's going to give you a very, very short description of what this thing is. It might say on the complaint, it might say complaint for damages. Or if it's a motion for summary judgment, it might say plaintiff's MSJ. Okay. Now, the one difference between the complaints and the motions, once you get to the stage where you're filing a motion, which is after the complaint's been filed, you don't put the people's addresses anymore, and you only list the first plaintiff and the first defendant. Everybody else is et al. So E-T space A-L period comma. So that means there's other defendants. And if you want to know who they are, then you're going to have to go look at the complaint. So that's how that looks. Now, underneath that, centered right about the middle of the page after the caption, you're going to have a more detailed description of what we're looking at. This is not going to say plaintiff's MSJ. It's going to say plaintiff's motion for summary judgment against defendant, Boeing Airlines, and that'll be what this is about. Okay, so now the judge or anybody looking at it can say, okay, we got a motion for summary judgment here, or this is a motion in limine to exclude evidence of this, that, or the other. So that's going to be that. In a criminal case, it's still going to be the same way with the caption. You're going to see State of Ohio versus, and it's going to say plaintiff versus Jim Jones defendant, or if it's a multi-defense case, Jim Jones et al. So the first section, that thing that's going to be more detailed, where it says plaintiff's motion against for summary judgment against so-and-so, maybe they file a defendant's memo contra to plaintiff's motion for summary judgment filed on June 16th, 2019. That's, it gets real detailed. Some of these things can almost look like a paragraph themselves, but it's going to tell the court exactly what the motion or whatever it is that it's looking at. Now, underneath that, we're going to have three sections where we're actually going to get into the meat and the bones of this motion. The first section is what's going to be your introduction and factual background. You're going to be telling the decision maker, this case is a case where it arises out of a kidnapping, or this case arises out of fraud that an accountant perpetrated upon his unsuspecting client, or something like that. Okay? Give you a little bit of a taste of what's going on overall in the case, and then you're going to immediately get into the facts that are important to the motion. Okay? So it'll say, on January 17th, so-and-so did X. And then they might support that with an affidavit that's attached to the back of the motion, or maybe if there's somewhere in a deposition transcript where they admitted that happens, you'll see that deposition there, the passage from that deposition or whatever it is, and give you all the facts that you're going to use in your argument, in your legal argument that's coming up. But Roman numeral 1, the opening salvo, that is these are the facts, the introduction and the factual background. Number 2, section number 2 is what's going to be the law and argument section. Okay, plaintiff's claim must fail for 3 reasons, and then it's going to say A. Plaintiff has failed to state a claim upon which relief can be granted in count 1. B. Everybody says that so-and-so did not do this, and plaintiff even says that he's not sure, therefore this case should be dismissed. That's B. And then argument C, even if this was what defendant did, he was privileged to do so because of his status as X. Maybe he's a legislator, or it's a defamation case. A legislator could say anything he wants on the floor of the body to which he is elected to serve. He has an absolute privilege. Lawyers have a privilege. Witnesses have a privilege to say things in court and not be going after for defamation. It's just a privilege, okay? So maybe your third argument is that the case must fail because of privilege, okay? And then you give your legal arguments as to what's happening there. So what's happening is, first you show what you say the facts are, then you apply those facts to the law in the law and argument stage. Then you get to the third Roman numeral, and that's just conclusion. Now, some people just have a very, very short conclusory section. They say, for the foregoing reasons, the court should X. And basically, in the conclusion, you can either do this. You can give us a short version of what you just said, and sort of like one last quick punch of argument there, and then tell the court what you want the court to do. Other people, they're like, hey, I already argued that. I'm just going to now tell the court what I want the court to do. And so in my conclusion, therefore the court should overrule the motion of the plaintiff or the motion of the defendant, or therefore the court should dismiss this portion of the case. And that's in your conclusion statement. Then you put respectfully submitted, and here's your signature, and then underneath that, here's something that most people don't think about if they're lay people and not attorneys. You have to have what's called a certificate of service. In Ohio, it's called Civil Rule 5. In most other states, it's probably called Civil Rule 5-2. But it's something that shows the court that you didn't just file this in secret, that when you filed it, you then actually sent a copy of it over to the other side right around the time when you filed it. And now they are going to have 2 weeks or 3 weeks or whatever the time limits are to respond to your motion. Now, if you don't have that certificate of service down there, technically the court's supposed to say, into the trash it goes, because you didn't serve the other side. They can't answer then. I'm not going to rule on it if I'm not going to hear from them. So you have to have that certificate of service where you say, I certify, or the undersigned hereby certifies that a true and accurate copy of the foregoing was sent to Jane Smith, Esquire, the attorney for the defendant, at her offices at 123 East Main Street, Columbus, Ohio, 43215. On this 20th day of February 2020 or whatever it is, okay? Now the court can look down there and see, okay, this was served on the other side, the clock is ticking on their answer, and I'll probably be getting an answer from them soon. Now, if you don't have an electronic filing system with your court, then you actually have to get the copies, they file stamp them, and you always want 2 or 3 extra copies, so you can keep one for your file, and you can send the other one over to the other parties in the case and their attorneys by mail usually. If you have an electronic filing system, a lot of these electronic filing systems, the moment you file with the court, it automatically shoots out a copy of that. Like the PACER system that's used by the federal courts, it automatically distributes a copy to every other attorney who's on the case. And so everybody's got it now. And so your certificate of service says, the undersigned hereby certifies that the other side was served via the court's electronic filing system, PACER. Okay, kind of superfluous at that point. But if you don't have that certificate of service down there, you got a problem on there. So this is the vessel into which you're going to pour your facts and your arguments and what you want the court to do. This is, you can even set it up as a template so you don't have to keep on retyping and reinventing the wheel each time. You don't have to keep, in the United States District for the Southern District of Ohio, Eastern Division. You don't have to retype that every time. You just have it as an MS Word document, and then you just fill in, okay, this is the Smith versus Jones, and here's the black versus green, and here's the so-and-so versus so-and-so case. You just type in the names, you type in the different case numbers, different judges, the different facts, the different arguments, and the different conclusions, and the different certificates of service, because everybody's going to have different addresses, obviously. So that is the vessel that you use to file motions, memos contra, replies. So basically, if somebody files a motion, then the other side files a memo contra, and then the side that filed the motion gets to file a reply. Now, there are page limits to these things. Those are all going to be in the local rules. Like in Franklin County, they don't want to see you filing something more than 25 pages. If it's a really, really complex case, hey, you can do that, okay? It's all right, you can do it. You just have to seek permission from the court. So, Your Honor, this is a real complex case. I need more than 25 pages. I'm going to file a motion for leave to file a motion that is more than X number of pages. The court's probably going to grant that, okay? For instance, in the United States District for the Southern District of Ohio, Eastern Division, they've got a local rule that if you're going to file a motion to dismiss and it's more than 25 pages, then, oh my God, you got to have all these, a big long table of contents, and every case you cite, you have to cite what page number it's on and all the sections and a short summary of each argument. It's like a big long spiel beforehand. It's a nightmare to do it, and it takes all sorts of time, but it sort of discourages you from doing a motion to dismiss that's more than 25 pages. If you don't want to do all that stuff, just keep your arguments tight, keep your facts pithy, and make it work within the 25 pages. Now, if you absolutely can't do it, okay, then just have your have all that extra stuff in there, and that's sort of the penalty that you pay. But that is the vehicle by which you are arguing to the court. You got your caption, introduction and factual background, your law and argument, your conclusion, your certificate of service, and then at the end of everything, if you're attaching exhibits, you know, like here's the lease, that's exhibit A, here's the photograph of the guy at the gas station, that's exhibit B, here's the place in the interrogatories where he had said that he did it on Thursday, that's exhibit C. So these are the things that the judge can turn to and look and say, oh, yep, okay, I see what they're saying. So that's the last part of any sort of pleading that you file, any sort of a motion that you file. It could be exhibits and affidavits and things like that. Basically, the hard evidence that supports the statements that you're saying.